Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In the last episode, we looked at parties and asked who can enforce a contract and who can become bound by one as well. Today, we're asking a slightly different question. Can this person make a binding contract in the first place? Most of the time, contract law assumes the answer is yes. Adults generally have the power to enter contracts. Businesses enter contracts every day. Consumers enter contracts every day. But there are some situations where the law steps in and says, not so fast. And that's where capacity comes in. Let's start by putting the big picture in place. Most people have unlimited contractual capacity. In other words, they are free to enter contracts and be bound by them. However, the law places limitations on certain categories of people and organisations. For SQE purposes, there are three main categories you need to think about: minors, persons lacking mental capacity, and corporations. And the key issue throughout is always the same. Should this person be legally bound by the agreement? Now let's start with minors. A minor is somebody under the age of 18. And the starting point is straightforward. Generally speaking, minors are not bound by contracts they enter into. That sounds simple, but there is an important catch. The other party normally remains bound. Now, the law recognises that young people may lack the experience and maturity needed to protect their interests. Imagine if a 16-year-old child could freely enter complex contracts for expensive items and be held fully accountable regardless of circumstances. The potential for unfairness is obvious, so the law provides protection. Now, the exam trap with this when it comes to SQE is that students often stop there. They remember minors are not bound, but that's only half the story, because there are important exceptions. The first exception relates to necessaries. These are goods and services that are suitable to the minor's position in life and actual needs at the time. Notice those words carefully. They are not essential for survival, but are appropriate for the particular minor. And this means that what counts as necessary can vary significantly dependent upon the circumstances. So imagine a minor purchasing food. That is likely to be a necessary. But now imagine a wealthy teenager purchasing formal clothing appropriate to their circumstances. That may also qualify. And the key question is, was the item genuinely required by that particular minor at that particular time? If the answer is yes, the contract may be binding. The second exception, it concerns contracts of service. These are usually contracts that provide employment, training, or experience. The law recognises that young people need opportunities to develop skills and build careers. So contracts that are beneficial overall may also be enforceable. The key question here, therefore, is whenever you see a minor entering a contract, ask, is this a contract for necessaries or a contract that benefits the minor? If not, the general protection will usually apply. Now let's move to the second category, people who lack mental capacity. And this can include mental illness, severe mental impairment, or intoxication. The important point is that capacity is assessed at the time the contract was made, and these contracts are usually valid. And that often surprises students. The law does not automatically invalidate contracts simply because a person later turns out to have lacked capacity. Instead, something more is required. Well, what more must be shown? Well, two things. First, the person must have been incapable of understanding the nature of the transaction. Second, the other party must have known about that incapacity. And both requirements matter because the law is trying to balance two competing interests. On the one hand, people who lack capacity deserve protection. On the other, innocent parties should not lose their contracts where they had no reason to suspect that there was a problem. So imagine somebody enters into a contract while suffering from a serious mental impairment. If the other party has no knowledge of that condition, the contract will generally remain valid. But if the incapacity was obvious and the other party knew what was happening, the contract may be avoided. So the key question here, whenever you see mental capacity within a problem, is you need to ask, did the person understand the nature of the transaction? And then, did the other party know they didn't? These two questions drive almost every SQE scenario involving mental capacity, so do please take note. Corporations are our final category, and they are slightly different. Here we're not dealing with vulnerable individuals, we're dealing with organizations. Now, a corporation is a legal person recognized by law. Even though it's not a human being, the law treats it as a separate legal entity. And that means it can own property, employ staff, sue and be sued, and enter contracts. But not all organizations have exactly the same powers. So let's start with registered companies. So for modern companies, capacity is generally very broad. In practice, a company can undertake almost any lawful activity, and this makes business transactions much easier. Third parties dealing with companies generally don't need to investigate every detail of the company's internal constitution. The law largely protects outsiders acting in good faith. Now we move to a different category, statutory corporations, and these include bodies created by legislation, such as certain public authorities. Their powers come from the statute that created them, and this creates an important limitation. The key question here is, was the corporation acting within its statutory powers? If the answer is no, the contract may be beyond its authority. Lawyers traditionally describe this as ultra vires, meaning beyond the powers. If a statutory body contracts outside its authorized powers, serious problems can arise. Finally, we have limited liability partnerships. For SQE purposes, these are straightforward. They have broad contractual capacity and can generally enter contracts without the restrictions that apply to some statutory corporations. Bringing it all together, students often try to memorize separate rules for minors, mental incapacity, and corporations, but they're all really applying the same principle. The law is asking, should this party have the power to enter this contract? And if not, what should happen to the contract? So what's Bowdie's bottom line? Well, every capacity problem starts with one question. Can this person make a binding contract? If the party is a minor, consider whether the contract concerns necessaries or is beneficial overall. If the party lacks mental capacity, ask whether they understood the transaction and whether the other party knew they did not. If the party is a corporation, ask whether it has the power to enter the contract. And remember, most people have capacity. Capacity problems are the exception, not the rule. The challenge in SQE questions is recognizing when one of those exceptions apply. Thank you for watching this Bowdie Shorts video. Please look out for the other videos available now. Thanks for watching.